In this lesson, we discussed the special rules that UCC Article 2 implements when we are forming contracts for the sale of goods. All right, if you remember our discussion from the previous module about contracts, you'll know that contracts have to have agreement, consideration, capacity, legality, and they have to be in writing sometimes, right? Now, UCC Article 2 changes 3 of these 5 elements when it comes to contracts for the sale of goods. So let's walk through the elements and see what is changed by UCC Article 2. We'll start with agreement. Now we know that agreement has 2 parts, right? Offer, acceptance. And UCC Article 2 actually changes the rules on offers and acceptance both. So with respect to offers, you know that if you say, I offer to sell you my bike for $100, that's an offer. Common law, that's an offer. It is also an offer for the sale of goods. So we have to think, does UCC Article 2 apply? It does. Does it change the rules? Well, not in that case, but in some other types of offers, UCC Article 2 will change the rules. And the most important way that UCC Article 2 modifies the rules pertaining to offers is that it permits what we call open terms. Now, when we discussed contracts in the previous module, we said that offers have to contain all the material terms of the contract, right? Like price and quantity and all that kind of stuff. But UCC Article 2 says we don't really need all that kind of stuff as long as there's some other way to determine it. It doesn't have to be in the offer as long as the parties have a method to determine it that they can both agree upon. So for instance, if I say I offer to buy 100 bushels of corn from you, well, I didn't put a price in there, right? The price term is an open term. But that's okay. Why? Because we know how much 100 bushels of corn is worth. There's a market for corn. We can just look up any given day how much corn is worth, so we don't actually have to have the term in the offer under UCC Article 2 for it to still be a valid offer. Now on the flip side, acceptances also are modified a little bit by UCC Article 2. Now, under the common law rules that we've already learned, how do you accept an offer to form a contract? Well, you say something like, I accept, or I promise to do this, or something like that. UCC Article 2 changes this a little bit, and the first way that it makes a change is by allowing acceptance by performance. So if I say, I promise to pay you $100 if you promise to sell me your bike, that's an offer to form a contract by both of us making a promise. But if instead of promising to sell me your bike, you just ship me your bike, now, you're not accepting my offer in the way that I wanted you to accept my offer. But UCC Article 2 says that's fine. A seller of goods can accept an offer simply by just shipping the goods. And that forms a valid and enforceable contract. Now, even beyond that, a seller of goods can accept an offer by shipping the wrong goods. You can actually ship non-conforming goods, what we call the wrong goods, and if it's what we call an accommodation shipment, it's still a valid acceptance. It's essentially an acceptance in an immediate breach. So if I say, I want to buy 100 blue bikes, and you ship me 100 red bikes, you still accepted my offer, but you immediately breached it by shipping me non-conforming goods. But if you tell me, hey, this is an accommodation shipment, and I get the 100 red bikes, and I'm like, you know what, I kind of like these red bikes, I'll keep them, then once I accept them, your breach has been cured, and there's no problem anymore. So shipping the goods, shipping non-conforming goods can both be methods of accepting an offer under UCC Article 2. Now, what about consideration? We learned about consideration. What is it? It's like a bargain for exchange of value. You got to bring something of value to the table. Well, the rules under UCC Article 2 are pretty much the same, with one small exception that if you want to modify a contract, the common law rules sometimes make you provide new consideration to modify a contract. Under the UCC, no such rules. You can modify contracts as long as both parties are acting in good faith. You don't need to provide any new consideration to modify a contract. Okay, capacity and legality, this is easy. UCC Article 2 rules are the same as the common law contract rules. So when we talk about infants, the insane, the intoxicated, illegal contracts for illegal purposes, things like that, all the same rules. Don't need to worry about any differences for UCC Article 2 there. But when it comes to the statute of frauds, the requirement that some contracts must be in writing, There is a little bit of a change. Now, we've already actually learned that contracts for the sale of goods in excess of $500 do need to be in writing. And that's actually, we get that from the UCC. So when we learned that in the previous module, we learned that because the UCC sets forth that rule. But there are some exceptions to that rule provided by Article 2. First, if the buyer has already accepted goods, the buyer cannot then refuse to pay on the grounds that the contract wasn't in writing and it should have been in writing because the goods were valued at more than $500. This is just not fair, right? You've already accepted the goods, you need to pay for the goods. You can't get out of it because the contract wasn't in writing. Next exception, if the goods are specially manufactured for the buyer cannot be excused from the contract because it wasn't in writing when it should have been. Now, the theory behind this is that, look, if you're a manufacturer of goods and you manufacture unique and special goods, you're not going to do that for no reason. You're not going to do that unless you had a contract. So, was your contract supposed to be in writing? Yes. But can we safely assume that there actually was a contract even though it was verbal? Yeah, because you're not going to manufacture specially manufactured goods if there wasn't, so we're going to enforce that contract even though it wasn't in writing and it should have been. And then finally, if one of the parties makes what we call an admission, usually in court or a deposition or something like that, that there was a contract even though it was verbal and should have been in writing, if you admit that there was a contract under oath most of the time, then a court will hold you liable for performance under that contract. Now, the last important rule that we get from Article 2 with regards to contract formation is called the parole evidence rule. And it's parole spelled P-A-R-O-L. That's not a typo. If it has the E on the end, that's what happened when you get out of jail and you have to go live in a halfway house. The P-A-R-O-L is actually related to the word oral. And you can actually think of this as the oral evidence rule. It basically states that if you have a written contract, you cannot use any previous oral agreements. You cannot enforce anything that happened prior to that contract if it contradicts with the terms of your contract. The assumption is if you have a written contract, we assume that that's your final agreement, and any prior agreements that might contradict this are just null and void. Now, that helps us sometimes, but sometimes we actually have ambiguous terms in a contract that we could say, yeah, this is your final agreement, but we don't know what it means because there's an ambiguous term in there. And thankfully, Article 2 actually helps provide a mechanism for helping us determine what we mean by ambiguous terms. So let's take an example. Say I am a rancher in my home state of Texas and I have lots of head of cattle, right? So I want to buy some corn. So I call up a farmer in Illinois and I say, hey, I need to buy 1,000 bushels of corn. And that's our contract. We can put it in writing so it's written, satisfies the statute of frauds, everything like that. But there's a couple different types of corn, right? There's feed corn, that's what you feed to animals. There's sweet corn, that's what people eat, but I didn't specify. That term corn in our contract is ambiguous. So how do we know which type of corn we wanted? Well, Article 2 says, here's what you do. First, you look at what's called course of performance. Under this same contract, do we have any history that would indicate what type of corn you want? Now, if this was the first time I ever called up this farmer and said, give me some corn, then there's no course of performance history. But maybe we already had a contract that said, I'll ship you corn once a month for the next 5 years. And for the first 2 years of the contract, the farmer shipped feed corn. Well, the court's going to say, look, for the first 2 years of this contract, this word corn meant feed corn. Therefore, for the rest of the contract, we assume it means feed corn. That's course of performance. Under this same contract, how have you interpreted this term? But if you don't have any history under the current contract, the courts will next look to what we call course of dealing. This means, okay, this contract has no history, but do these parties have a history with each other? Have they engaged in other contracts in the past? And if so, can those help us understand what they mean? So maybe this farmer and I had a previous contract a couple of years ago where I bought some corn and they sent feed corn, and that was fine. So a court will say, look, in the past, you used the word corn and you meant feed corn, so we're going to assume this time when you use the word corn, you also mean feed corn. But that doesn't always help us. Course of performance, course of dealing assume that the parties have had business with each other in the past. If they never ever have done business together in the past, then we look to industry usage. So in general, when a cattle rancher calls a farmer and offers to buy 1,000 bushels of corn, in their industries, would this usually be feed corn or sweet corn? Well, I'm a hungry guy, but I can't eat 1,000 bushels of sweet corn myself. So industry usage would dictate it should be feed corn. And if you wanted sweet corn, then you should have specified otherwise, because in your industry, we would assume that you meant feed corn. Your industry is cattle ranching. You buy feed corn to feed your cattle. Therefore, industry usage will dictate. Now, does this solve all ambiguous terms? No. But it's a really helpful method provided by Article 2 to help us resolve some forms of ambiguity.